All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in case number CV24-0398 Sanchez versus Shawcroft. These proceedings are being video and audio recorded and live streamed. And so, counsel, we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible to watch the clock if you'd like to reserve a portion for rebuttal. Also, please keep in mind that we've read the briefs. We've conferenced the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honors. May it please the court, my name is Daniel Brill. I am counsel for the plaintiffs and appellants in this matter. As you're familiar with the briefs, as you mentioned, I will kind of try to cut to the chase. I represented an adult and 4 minor children that are still today minor children for a September of 2019 motor vehicle accident. We filed that lawsuit. It was a tier 1. We first filed a notice of claim because of the municipality that was the tortfeasor or defendant, and then we filed the lawsuit timely. We served it. We went through discovery and disclosure. We had an arbitration hearing, which we submitted an arbitration statement. My clients testified. The arbitrator issued a notice of decision in favor of my clients.
Counsel,
Yes.
just and we're aware of these facts, and they're important facts. Why the 2-year delay?
Your Honor, that's a good question. And what I wanted to point out why I was giving you that timeline is because we used the term prosecution and act as if the plaintiffs didn't prosecute their case. Mm-hmm. Really what we did is we took the ball 98% down the field, and the only thing we didn't do was get paid. Mm-hmm. And so
you had a 2-year timeout on the 2-yard line.
No, understood, Your Honor, and that is understood. But you could keep in mind is this was back in the time when we had the pandemic, courts were operating remotely, law offices were operating remotely. There's a lot of chaos going on as far as people were filing by email, e-service, regular mail. Employees are working remotely. It was my understanding that that case had been was going to be processed as a settlement with the associate Ian Beck, who had left the firm in December of 21, which you can take judicial notice. It's on his LinkedIn page. I don't believe the defense is going to dispute when the associate I had the agreement with the process as a settlement left the firm.
Counsel, let's jump ahead to the settlement. I'm at your appendix, pages 143 to 45, which is the email exchange that you had with Attorney Beck in November 2021. Are you really saying that email chain comprises an agreement to settle?
Well, Your Honor, I think you need to keep in mind is that what's usual and customary in a community on these compulsory arbitration cases is that we process them as settlements. Maybe 2 times out of the 400 plus cases I've arbitrated have I actually lodged a judgment, because usually this is common. And so
when you say this is common, I think you mean they just usually pay the amount of the arbitration award, right?
Right, and they send you either a satisfaction of ARB award or a release.
But in the email correspondence, I think you requested some multiple of the arbation award.
Well, what I did, but if you look to my email, it also says if my client does not appeal, go ahead and process it as a settlement, which is customary. So when the appeal deadline ran, my expectation was that they would send a check and a satisfaction of ARB award or a stip to dismiss or release. And since my office was working remote, and a client's name is Sanchez, and it was an oversight that we never received the settlement documents, and it wasn't processed. And go ahead.
Counsel, I just keeping with my question with Judge Catlett's follow-up in mind, your November 2, 2021 email, to drill down it more precisely, it doesn't say go ahead and process this as a settlement. I think this morning I went through and I found 4 different ways in which you're not accepting whatever Mr. Beck said before that. He offered to pay the full amount of the arbitration award, but they didn't want a judgment on their scorecard. That's their thing. They don't want to have a loss showing on the flag above Wrigley Field, I guess. But over here, you 4 times decline the offer. You say, I conveyed the arbitration award to her. She's unhappy. It's too low. So you want more money than they're offering, number one. You say, I finally obtained authority to accept $32,000 for Sabrina and $52.50 per child. That's more. That's number 2. They are conditioned, you wrote, on settling together. So you need all this together. If accepted, so you're understanding that that's different from what he said, we would process it as a settlement. But you're saying process it as a settlement at a higher amount than the arbitration award. So you did not accept his offer, right?
I didn't accept the offer of the award at that time, but the procedure of how we were going to conclude the case was agreed in my mind that it would be without, if nobody appealed, if my client does not appeal. Right. That didn't change all I did was talk about the amounts. And when it did go final, which is customary, it goes, we calendar 20 days, it goes final, we know it's not appealable. And now the question is most practitioners will send the check with a satisfaction arbor award. In this case, it didn't happen. And I don't know if it didn't happen because, and a lot of it was because of the confusion of what was going on with the pandemic and everyone working remotely, that I never got the 12-8. To my recollection, the 12-8 administrative order, and I was under the impression that my accounting department and bookkeeper processed the settlement already, because it wasn't until, you're right, almost 2 years later that in an audit we realized that it was never paid. But at that point, though, I filed the notice of settlement under the belief that it settled. But in
the amount of what he had written that you had rejected.
Well, and basically we didn't appeal the arbor award, which is what originally was agreed upon. If we didn't appeal the arbor award, then we would process it as a settlement. And so...
in a higher amount than the arbor award?
No. When the arbor award became final, then that's the number that my clients were stuck with. So Now the next question then becomes, though, if at the time that administrative order came out, that says the court has to dismiss in 30 days, it never does. Judge Warner, who was the judge at the time, doesn't dismiss it. Judge Ryan Toohill doesn't dismiss it. And so when I realized they're not going to honor what I believed was that we were going to process that way,
when you realized they declined your counteroffer in the November 2 email.
Well, obviously I knew they declined the counteroffer, but I still under the impression, because that's what's usual and customary, is that we process these as settlements. And so when that occurs, and he actually, if there's a November 30th email from Mr. Papalizio that says, go ahead and file your judgment and have a great afternoon. And so I did. I lodged my judgment because the case is still active, Your Honors, because it required under Rule 58 a signed order. This was an administrative order, so the judge or judicial officer had to sign it. And so therefore, it's still active. I then lodged judgment. They don't object to the judgment.
Well, let me slow you down on that one, because you're right. You're totally right. They didn't object. So you go ahead and lodge it on December 4, and then the court says before the court in the dismissal calendar order dated December 13, so 9 days later, the court says to everyone, I have Mr. Brill's notice of settlement. Great. It is ordered, and this is after you lodged your judgment, too. Court has the judgment in hand, tells everybody, unless a stipulated judgment along with the proposed form of order is submitted to the court before that date, all remaining claims and parties will be dismissed. So isn't the court telling them that if they don't stipulate, the court will dismiss the case?
Your Honor, I think it presents it should be a non-issue for the court or for the judge, because she, even in her oral argument, admitted that's just a standardized thing. But if the defense disagree there's a notice of settlement, they also have the right to move to strike it. And then when he told me go ahead and lodge the judgment, and he got the judgment, and the judgment clearly states, if you read the judgment, it's arising from the arbitration award of 2021. So there's no confusion anymore. And so you would think that the lack of objection is an acquiescence or a waiver in my mind. And then it gets entered, and it's not till 14 days later that he comes back with a Rule 59 motion because he knows Rule 60 doesn't apply because he doesn't have a meritorious defense.
Well, counsel, several things occur to me in listening to your explanation of it, and one is that even though you said it was a notice of settlement, the judgment you lodged 5 days later is not on any term that was ever agreed to in a Dickard settlement between you and opposing counsel, Mr. Beck. Instead, it's the original award. It's as if there was never a notice of settlement, because the judgment that you lodged doesn't talk about settlement, it just goes back to the award, number one. But the second thing that's interesting is, so even when the court says, I guess you're saying because it's a standard order, they should disregard the language of the dismissal calendar order saying that the court will not enter judgment? They're not entitled to rely on that court order?
I understand your position, Your Honor. No, what I'm saying is
just
that
a question.
if the defense believed that the notice of settlement was erroneous, they should have notified the court. If they believed that the lodging of the judgment was improper, should have notified the court. But they didn't. So I would argue that their acquiescence.
So they had to object despite the court order saying they didn't have to object?
Well, it didn't say they didn't have. Well, the judge signed the order, so why, or signed the judgment? So why would the judge sign the judgment if she's under the impression that her prior order said it had to be stipulated?
I totally agree that the court's later action seems to ratify your view of it. The problem is that the court has an inconsistent court order, and they seem to be allowed to rely on court orders, no?
Well, the judge originally took responsibility for her mistakes. She even mentioned she had a high volume. I imagine she was running under the same restrictions and chaos caused by this pandemic. And so
You're saying you're running on two tracks then at that point, the notice of settlement track and the proposed form of judgment track?
well, I'm saying the notice of settlement.
And I know the notice of settlement triggers the order, but
Correct.
then you're saying the defendant should still independently comply with the rules that I think give them maybe 5 days to object.
Correct.
To the,
I mean, I think it really moots the notice of settlement because they're denying that it even existed. And so why not take, if I'm the defense attorney and I'm seeing a notice of settlement and a lodged judgment, why am I not saying, hey, Your Honor, there was no settlement, you should strike that, and why aren't you
well, that's my
objecting?
question. Why didn't you say that to the court? When it became clear that
Well,
they had
because
not
he-
agreed to the settlement, I think it would have been helpful for you to say, I withdraw my notice of settlement. I'm just filing a proposed form of judgment that mirrors the arbitration award.
Your Honor, I assume that could have been on. I could have withdrew the notice of settlement, but I believe it essentially was moot. But also, the email on November 30th from defense counsel was, we don't have a settlement, go ahead and lodge your judgment. So I want to lodge my judgment figuring, okay, he'll object now, right? But he never objected because, in my mind, he acquiesced or waived his right to challenge the judgment. And so then when he moved to vacate it, I was shocked. But then when it gets vacated, it's vacated under 76D without prejudice. So, okay, then I have the right to refile because the minors, there's no adjudication on the merits. It's just without prejudice, it's gone now. So nothing ever occurred. There's no res judicata. There's no claim preclusion. I have 4 minors that still have valid statutes I can refile. And the only real question was whether or not the adult plaintiff was entitled to 12504 relief under the same statute. I also want to point out that I had moved to strike the judge under the statute 12409. The court was required. It says shall. Under number 2 and 5, I had an affidavit saying I didn't believe that the judge could be fair and impartial.
Well, 12409 is given body in, I think it's Rule 42 or 42.1, and for some reason you chose to strike Judge Blaney. So you could have saved your strike for Judge Ryan Toohill, no?
Correct, but that was my peremptory strike, was on Judge Blaney.
Right.
Then it went to Judge Blanchard, who I had no problem keeping, and then they moved under Local Rule 3.1 to remand it back to Ryan Toohill.
Well, 3.1D says the court can do that on its face, right?
But the intent and purpose of that, Your Honors, is because they think that judge is familiar with the merits. But this is a simple car accident, so there's no real judicial economy by sending back a simple car accident to that judge.
Well, actually, she's familiar with the nested set of rulings that we're debating here today, isn't she?
Your Honor, but she's also interested in the outcome in the sense that she's taken responsibility on the record of contributing to the.
She said it was the court's error, but the court's administrative error is not mostly chargeable to Judge Ryan Toohill. It was Judge Warner's case for most of that time, and it's something the administrative part of the court deals with, typically sending the notices, right?
Understood, but she had misculpability and confusion and contributing to it, and all the technicalities that we as a the courts have a preference to hear these cases on the merits, not dismiss on technicalities. And really, what's the technicality is we prosecuted the case, we won the case. The only thing we didn't get was a check, and that's the definition of technicality is basically a procedural issue that doesn't go to the merits of the case. Well, the merits of the case was this car accident collision that my clients were injured as a result of the negligence of the defendant, and for them to escape payment because of this technicality of not lodging a judgment, when I filed the judgment, even though tardy, it was still an active case. And so she had no reason not to, she signed it, and they didn't object to it. And it also was very clear in the judgment that this arises from the 2021 arbitration award. So there's no reason to go back and later vacate it. What she should have found was excusable neglect because two judges and two parties all missed that administrative order dismissing it. And so
I'm a little confused. What are you seeking in the second action? Because I looked at the complaint, and there's not a claim in there to enforce the arbitration award. You're just refiling a negligence claim.
Correct.
So are you seeking to relitigate what happened in the arbitration?
Unfortunately, I was left with the position that I appealed the first one.
Right.
And I then stayed it immediately. So I can see if I could remedy it through 12504. And also because I knew the statute hadn't run out of the minors because it was dismissed without prejudice. So therefore, that I thought would be more expeditious. I wouldn't have to wait a year and a half to get a ruling on the first one, then I'd come back down and then refile under the savings statute. So I stayed it, refiled it.
I guess, if the second case were to go forward, do you plan to use the arbitration award?
No, I just
in
relitigate
an
from the
offensive
beginning.
matter, like using offensive matter, like they're barred from re-arguing the
No,
issues?
I believe
because you won?
I think there's no findings of
it's blank
fact.
slate.
Right. Yeah, clean slate. There's no claim of conclusion, there's no res judicata, there's nothing. It's like it never occurred. It's without prejudice.
What about 12133, where it says that the arbitration award is supposed to function as a judgment? What you just said seems to be in tension with that.
Well, the challenge with 133, which I agree, it should automatically apply. But Phillips' case, I think you should overturn the Phillips case because I think it's been 10 years and I don't think that's followed on a regular basis. But on the other hand is the statute 12133E and the conflict. And so basically Rule 76 creates that that conflict between, but I agree that in that case,
I think you could harmonize those two and say the arbitration award has the effect of a judgment, but for purposes of finality and triggering an appeal under the court rules, we need a separate piece of paper. And so that 76D is just sort of implementing that process.
I guess I understand what you're saying with that, but I think the way that the court the rulings played out, 12504, dismissing it without prejudice, then left me with. So I either would like this court to either affirm the original judgment.
Well, that was, and I think you're anticipating my next question. And I'm not saying we're going to do this, but if we were to say the court erred in setting aside the first judgment, it's back in place. Do you agree that the second action, it's moot?
Yeah, because it's already been.
I know you have arguments that are probably not moot about sanctions, but the dismissal of that second case would be moot at that point.
Correct, because the first judgment is valid then.
Right.
But I'm left, if you vacate that first judgment, then I'm left with having to relitigate the same case, which defies judicial economy. But on the other hand, I'm prepared to do that, is to relitigate the case all over again. I have 4 minors and an adult, and we prosecute the case. But so I do believe that affirming the original judgment should be done. I don't think it ever should have been vacated. But alternatively, I believe that my second complaint should be able to move forward and the case be heard on the merits because there's nothing that precludes it. The statute's still good on the kids, and 12504 is applicable, or I believe that factors apply for the adult. But I also believe that the case should go back to Judge Blanchard because I think 12409, the court should have not reassigned it back to Tuho Ryan. or Ryan too, I apologize. And she, anything that she ruled on after that date should just be void, and including the sanctions, because the sanctions, which I have about 45 seconds, so I apologize, I want to reserve a little rebuttal. But the sanctions are egregious. I mean, 3 weeks to draft a 12B6 motion. That's 123 hours for a standard 12B6 motion. That was mostly cut and paste. And so, if anything, I think the record's clear that, and the 9-page minute entry, that she attempted to punish me. I got that impression when I originally moved to not, from the first thing, when she made a comment about my malpractice carrier. I mean, there's stuff that just seemed that 12-409 should have applied. I didn't feel I can get a fair and impartial trial, and I don't believe I did. And therefore, I believe that I would like this court to either affirm the original judgment and then everything else is moot thereafter, or remand the case to Judge Blanchard, vacate everything post. Let me relitigate the case on the merits, because that's the preference of our courts.
Thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the Court. My name is Ashley Caballero-Daltrey, and I represent the defendant, Officer Tyson Shawcroft, in this matter. With me at counsel table is partner Joe Popolizio. This is a case about the failure to follow the rules, which was compounded by multiple filings across 2 cases involving the exact same underlying actions and the exact same parties.
Hey, counsel, let's talk about Rule 80. Rule 80, as a refresher for everybody in the room, is the rule that enforces written agreements of counsel. So there's this very interesting fact that your opposing counsel alluded to, but there was a writing, I think it was from like November 16 or so, 2023, where someone in your office said, just go ahead and submit a judgment on the terms of the arbitration award. Now, he didn't do what my question is going to say. I get it. But if he had written back and said, I accept that and I'm going to do that, this is an agreement of counsel under Rule 80A, isn't this case over?
If he had done that, I believe so, if it was on the original terms of the original arbitration award.
Right,
Yes.
which is what he ended up submitting as a judgment, albeit without confirming back that he would do it in response to your firm's offer to have it be done. So then, how can it go from November 16 or so, 2023, there's a potentially enforceable agreement to have judgment taken on the very terms he then submits 3 weeks later, albeit without confirming it, we got that, then how can that morph in a few months into the entire case can be dismissed forever for lack of prosecution? That's the fundamental global contradiction I have a difficulty with looking at the other side of this.
I understand the concern, but under basic contract law, and if an offer is not accepted within a reasonable amount of time, by operation of law, the offer is rejected. So we have 2 ways that Ian Beck's original offer was rejected. First, it was rejected by the counteroffer that came in that email where plaintiff's counsel said, $32,000, a higher amount than the arbitration award. So it's rejected because of the counteroffer. It's also rejected by the amount of time that passes between the time of Ian Beck's email and 2 years later when the judgment is lodged.
But you're answering the question with respect to the email correspondence from November 2021. I am asking about in November 2023 when your office predecessor associate on the file wrote to Mr. Brill and just said, go ahead and seek judgment on those terms.
Oh, I'm sorry that I didn't understand that, Your Honor.
I apologize.
That email specifically was intended to ask plaintiff to file a judgment so that the case would be over and we could get into these discussions about whether or not the case was in fact final, start the appellate clock, start all of those things. I don't think that email evidences an intent to accept a previous offer. I think at that point, communication between counsel, it had been 2 years later, it was clear that they weren't communicating, and so counsel said,
I think what Judge Jacobs is suggesting is it's the email suggested a course of conduct that your client through counsel would be okay with, i.e. lodging a judgment, and then through counsel's conduct, he accepted that course because he filed a proposed form of judgment a month later.
I think
Granted, there was a notice of settlement that was inconsistent in the interim, but
right. So there's a couple different factors. So like you mentioned, there was the notice of settlement in the interim. So already there's a lack of agreement of where we are in this case, if there had been a settlement, if there hadn't.
Yeah.
There's also
and I don't think anyone's moving to enforce that settlement, and I don't think we would even if they did.
Right. So you've already got a lack of agreement between the parties just from the fact of filing a notice of settlement that did not reflect a true settlement. The other issue you have is, again, there's been this 2-year period between the time of the initial conversation and now this conversation. We might have a different case if, for example, in the email in 2023, we had said, we intend, well, let's go forward with the settlement, go ahead and file your judgment. Let's go back to the original terms, go ahead and file your judgment. But I think because the email was limited to just go ahead and file your judgment, in the context of a frivolous notice of settlement had already been filed, we tried to tell plaintiff's counsel that the parties hadn't settled. It was clear that the communication had broke down. At that point, it was file your judgment, intending that we would object, intending that we would file a Rule 59 motion, Rule 60 motion, if that's what happened.
But you didn't object, right?
The time to object passed before we were able to do so. So the court, in fact, talked about that in her order on this issue in the second case. The time for us to, she signed the judgment before the time to object. Also, we were relying on the court's order that said it will be dismissed unless you file a stipulated judgment. This wasn't a stipulated judgment. Then, as soon as the judgment was in fact signed, we moved under Rule 59 and Rule 60. In the briefing, plaintiffs said that we only moved under Rule 59, but that's not correct. We moved under both rules. And so, defendant really this entire time has been trying to object to it. It's just the timing was off on this particular piece of it. But I think we really have to go back to the fact that 2 years expired between this initial offer, which was rejected via counteroffer, which was rejected over time, and then we get to this email in 2023 that after a frivolous notice of settlement, just saying, go ahead and go with your course of action, and then we'll take our action.
So you're saying the email was after November 30? I thought it was a couple weeks before November 30. But either way, counsel, how is it consistent with saying 2 years is the hang-up, and then your firm is saying go ahead and lodge a judgment? If I think you waived something 2 years ago, and I think your brief basically in this court amounts to that you could have moved to dismiss the case for lack of prosecution on January 9th, 2022, there's no limiting principle in your brief. It's 30 days, got to do it, jurisdictional, done, you're dead. If that's true, then why is your firm offering 23 months later, go ahead and have a judgment entered? It's confusing, and it seems very inconsistent, frankly.
Because it was our position that the case had been dismissed by operation of law under Rule 76. So our position was that if the notice of judgment was filed, it would not be correct if it was trying to reduce it to the arbitration award, because the case was already dismissed as by operation of law pursuant to Rule 76 and Phillips versus Garcia. And then at that point, we would object to the judgment and make those arguments.
So you're saying your firm encouraged him to file a judgment that you subjectively believed would be invalid as a matter of law, but you just weren't saying that.
At that point, we didn't believe that additional communication was going to resolve the issue, because we had tried to talk to plaintiff's counsel to try and stop this from occurring. I know that we briefed and it's in the record, the chain of emails, the discussions between the party leading up to this point. And I think that email just came from a place of saying, okay, this is the action you're going to take, and then we'll move forward with our action.
But it doesn't really say that. It just says go ahead and file a judgment.
Correct, Your Honor. But it also doesn't say we accept your settlement from 2 years ago.
No. I didn't read it that way either, counsel. I think you're right about that.
So is it your position then that 76D is jurisdictional? If the court doesn't comply with the deadlines in 76D, it no longer, as a matter of law, can enter judgment at that point?
I think if you read together 133 and Rule 76D, that's correct. Once the arbitration award finalizes everything, then the only thing the court can do is either wait for a judgment to be filed or dismiss the case. It must dismiss the case under Rule 76. And in Phillips versus Garcia, the court said that it harmonized those two. It said that there's no conflict. It does not frustrate, but rather advances the intent behind the statute. So these work together, and yes, by operation of law, at that point, the only thing the court could do was dismiss.
And Phillips was a case that came out before the without prejudice language was written into Rule 76D, right?
That's correct, but I think you see this timeline of cases continually upholding the arbitration award. So Phillips versus Garcia also came after Graff versus Whitaker. Graff versus Whitaker was the previous arbitration rules. Each time the rules are updated, we see the court finding that those rules are harmonized with 133. And also the without prejudice language in this particular case, is still with prejudice because the statute of limitations had passed for the adult plaintiff.
Well, that's the nub of it. Thank you for bringing us to that, counsel, seriously. So let's talk about the seeming contradiction between a Rule 76D dismissal without prejudice and your successful in the Superior Court effort to have it be treated as a Rule 41B dismissal for lack of prosecution. How can those two rules be reconciled that way?
You reconcile them through the plain language of ARS 12504. Because 504 itself references a failure to prosecute, and it talks about abatement and failure to prosecute. So as we know, a dismissal without prejudice, if the statute of limitations has passed, is with prejudice. And the only way it can be saved is the saving statute, 12504, but 12504 then steps in and says, but if you were dismissed for a failure to prosecute, if your case was abated for that reason, then you have to get the trial court's permission to refile. And so that's kind of where this failure to prosecute language is coming in, which has been ratified then through the case law interpreting 12504, like the Jepson case and other cases that say, if you're not diligent, the saving statute is not there to save cases that were failure to prosecute.
So counsel, do you know of a case, or do you cite a case in your briefs of where someone wins something on the merits, which they did, and gets a judgment entered, and then you can still say that the case wasn't prosecuted? That's an interesting concept. Do you have a case about that?
Not a case directly on point for what you're explaining, but I think there's a good analogy to the appellate jurisdiction cases like Chung versus Chalet. So in that case, there was a 54B judgment. Plaintiffs didn't review the record, didn't notice that the 54B judgment had been entered, waited, so the 30 days to appeal expired, 30 more days, 2 days after that, they were sent it by, the 54B judgment was sent by defendants to plaintiffs who realized, I didn't appeal. They went to then appeal. And
That 30-day deadline is in a statute, right?
Correct, Your Honor.
Not a rule.
Nevertheless, they said that this court found that they were not diligent in waiting the 30 days after the judgment had been entered because they had an obligation to review the court's docket and had an obligation to keep apprised of the judgment. I think from their perspective, they've gone all the way through the case and they've lost their ability to bring that appeal now.
Because they blew a jurisdictional deadline, to the point of Judge Catlett's question, and no one's saying Rule 76D is jurisdictional, and that's a pretty basic difference, right?
But Rule 76D read together with 12133 basically does create a jurisdictional problem for the court because 133, Rule 76D, and Phillips versus Garcia, which harmonizes those all together, says that once the award is finalized, that's meant to be a judgment. So you do have a statute in the background of all this.
But they got a judgment. How can they fail to prosecute a case when they won on the merits and got a judgment? Now, you're going to say, well, they got the judgment through a misleading filing, so they falsely prosecuted it. They misleadingly prosecuted it. But they prosecuted it. Nothing happens in a case after judgment, right?
But there's still, the rule says that they have to file the judgment. And the rule,
Well, they did.
But they didn't do it within the timeline prescribed by Rule 76. And there's a 30-day deadline in the rule, and the rules...
Well, I guess I might go one step further and say, under 12133E, it says an arbitration award shall be treated as a judgment. So, at least on some level, they got a judgment when they got the arbitration award.
They did, Your Honor, but
they didn't take the next ministerial step of actually getting a judgment from the court versus the arbitrator, but...
That's correct, Your Honor, but the Supreme Court in Phillips Garcia still said that Rule 76 doesn't frustrate the purposes of 12133. So the Supreme Court has held that this is the procedure that has to be followed. These rules have teeth, just like the rules of appellate procedure, just like rules saying that if a party fails to prosecute a case, it can be dismissed. We give teeth to rules of civil procedure to make sure they say what they mean, especially when those rules have consequences. This isn't a rule that just says this party must do something and then stops. Like, for example, the good
Are you aware of any other rule of civil procedure that's jurisdictional?
I think the other rules of civil procedure that work in a jurisdictional way also interact with statutes the way that Rule 76 does. So you've got, for example, the rules of civil appellate procedure work together with the statutes that grant you jurisdiction. And in conjunction, those create a lot of situations in which a litigant can lose their rights when they fail to follow the rules.
Right, but I think most of those rules also, assuming they're not jurisdictional, then the protections afforded to the parties by the rule can also be forfeited by the defendant or by a different party if the rule isn't urged early enough.
They could be.
So if it's a claim processing rule, then it can be forfeited. And we have a case here where 2 years went by and your client also didn't ask for judgment.
My client wasn't required to do so, and it
But
really...
your client could have done so. The
He
rule,
could have.
I understand practically. I represented defendants. I've been in your shoes. I know why you didn't. But the language of the rule says you could have.
But the language of the rule also says that it must be dismissed. There's teeth in this rule that isn't in other rules. So, for example, the good faith consultation rule. The good faith consultation rule says that before you file a motion to dismiss, you are required to consult with the other party and attach a good faith consultation certificate. And
If
this,
the opposing party, though, doesn't show up in court and say they violated that rule, then it's waived.
right, but this court has also said that even if you fail to file a good faith consultation certificate, that rule doesn't have any teeth. It doesn't end with anything. It doesn't say, and therefore this case must be dismissed.
Right.
So this court has found in the past, well, if you fail to follow the rule, there's no consequence. It's not written into the rule. This rule, the drafters explicitly put in a consequence. They said it must be dismissed.
Yeah, and I agree with that. And the U.S. Supreme, we don't have a lot of case law in Arizona talking about this, but the U.S. Supreme Court has said you have to have jurisdictional language in order for it to be a jurisdictional limitation. A claims processing rule doesn't have that language, but it does have consequences attached. And so I think this falls into that category. I agree with you. There are consequences attached to violating Rule 76, but I still don't think that takes you out of the claim processing type and puts you into the jurisdictional type.
Well, and the phrase "must" came into the Rule 76D, after the work of the Task Force on the Arizona Rules of Civil Procedure. Chief Justice Bales appointed it. It restyled the rules in 2015. It simultaneously put the "must" in that you're talking about. It also simultaneously put in the "without prejudice" that wasn't there before. And there are two 2016 cases from this court that say, gosh, this rule doesn't say dismiss means with or without prejudice. Maybe that can be like Rule 41B. The next year, the Arizona Supreme Court puts in without prejudice. So don't we have to enforce those words too?
I don't see that the decision would change if you enforce the without prejudice in this case because of the statute of limitations.
Right, but as you said it before, I think it's a very honest and forthcoming argument, but you're saying the with prejudice, you're saying the without prejudice here is with prejudice. I mean, you literally said that, and I think that's the position you need for your side to prevail here.
Yeah, and that's correct. In this case it is, and so you can read and enforce both pieces of the rule, that the court must dismiss and that it is without prejudice, because in this case the statute of limitations has passed. So
Well, I think you would say without prejudice doesn't mean that when the plaintiff files a second action, your client can't interpose additional defenses, including statute of limitations, right?
correct.
Right.
I mean, I think that would be true in any case that was dismissed without prejudice. You'd come into the second case and you would say, first you'd make the argument, the statute of limitations was passed, so the
first case is dismissed under 76D, second case is dismissed under statute of limitations. Those are two different things. That
Correct.
doesn't mean that the first wasn't dismissed without prejudice.
Correct. We're getting towards the end of the time, but one of the things I think we should touch on briefly is the sanctions, because plaintiffs did raise it at the end of their argument. I want to draw the court's attention to the fact that, first of all, plaintiffs never did any line item objections to the application for attorney's fees below. So plaintiffs are arguing now on appeal that it's an egregious amount, but we know that litigants are required to do line item objections if there's an issue with the amount of fees. The other thing is that this was not just a simple motion to dismiss. I mean, we're standing here talking about really intricate questions about jurisdiction, about rules, about the interplay of rules and statutes, and then we haven't even gotten to the minors issue with 12-502, some of the savings statute. I mean, even just now, we're talking about all these high-level questions within a motion to dismiss. This was not a routine motion to dismiss, and really, the fact that plaintiffs didn't object to any line items is pretty fatal to that reasonableness argument. But
Can you explain quickly that position on the statute of limitations with respect to the children?
yes, of course.
That seems kind of a unique argument to me I hadn't seen or thought of before.
I understand, especially there's not a lot of case law yet on Rule IRS 12502 and this disability issue, but I think as a matter of common sense, if someone brings a claim, even if they were entitled to toll the statute until later on, if they bring the claim, prosecute the claim, go almost all the way to the end of the claim, then they've sort of forfeited that tolling period. And we've seen
Even if the dismissal is without prejudice?
Even with the dismissal is without prejudice, I think you have to look at the actual nature of the proceeding, which is a different situation than, let's say, a notice of claim, a dismissal based on failure to serve a notice of claim. Like the Arizona Supreme Court in Lawrence said that it's not a dismissal based on a notice of claim, is not on the merits for the purposes of responding at superior. So we know that notices of claim are sort of treated as this early procedural mechanism. It's a very different posture than someone who has gone all the way through a case, gone through arbitration, had witnesses, had statements, got a ruling on it. I think in those situations with the tolling issue, you need to look at the underlying what actually happened here. It's not about is it with or without prejudice. It's about what happened in the case.
See, that seems more like a preclusion argument to me than a statute of limitations argument.
And in fact, that's why we included a claim preclusion argument in the alternative. I think they go hand in hand, and I think this court could decide it on either grounds, either by saying, you know, in this case, they did go through. I'm sorry, I see my time is over. Can I briefly finish the answer? So in this case, they did go all the way through it, and that stopped them from tolling it, or claim preclusion precludes their claims in the second case. So we ask that you affirm the trial court's decision. Thank you.
Thank you, counsel. Thank you both for the written briefs and your argument here today. You've given us much to consider. We'll take the matter under advisement, issue a written ruling in due course, and we're adjourned.